Somebody in the comments asked, since when have we had a Supreme Court? The answer being since 2010 or 2011, depending on whether you count when it was introduced as a concept or had its first case. But that's a good question. What happened to the old House of Lords? Well, to answer that, we need to go back in time a little bit. The English legal system used to be incredibly complicated. I mean, it still is, but it used to be worse. And I've mentioned before all these different courts that we had, like common law courts and equity, for one example. So that was two parallel legal systems, and they had their own separate courts. So you would start out in the common law courts, and if you got a result you weren't happy with, you would then try your luck in the courts of equity. In the 19th century, something called the Judicature Acts were introduced, and they reconciled the two, and they said, okay, what we'll do is we'll abolish the separate courts of equity, but all the equitable principles you can now just run parallel to your common law points in the same court. And at some stage we'll have to do a video on common law and equity because it's quite interesting. So, okay, so that was one bit of rationalisation. It's a bit like I've mentioned, Cornwall used to have its own legal system, Stanary law, and its own courts, the Stanary courts. When they got rid of the Stanary courts, they said the powers of the Stanary courts transferred to the county court, which is why there's the argument that Stanary law still exists. We also had loads of different tribunals, tax tribunal, land tribunal, criminal injuries compensation board. They all had different rules of procedure. They've all been, again, rationalised and reconciled, and now we just call them first and second tier tribunals, and the idea is that at least, the rules of procedure are the same in all of them. So, there's always been this move to just, sort of simplify things. As part of that, we now look at, our five main courts. We've got the County Court, the Magistrates Court, the High Court, the Crown Court, and the Court of Appeal. I mean, the Court of Appeal technically has a civil and criminal division, but for our purposes, we'll just call it the Court of Appeal. The County Court and the Magistrates Court are both what we call creatures of statute. In other words, they were created by Acts of Parliament, and all their powers are in Acts of Parliament, which makes it a lot easier to challenge them for what we call ultra vires. Ultra vires just means outside the powers. So it's easy to say, well, you're not entitled to do that because it's not written down anywhere that you can. And in the absence of that, you're just not allowed to. The High Court and the Crown Court, because the Crown Court evolved from the old assizes, where judges would go on circuit around the country, which is why courts still call them circuit judges. They're what we call courts of inherent jurisdiction. In other words, they've been around forever, and whatever powers they have, they've always had, and they're not necessarily written down anywhere. So they've got much broader remit and discretion for controlling their own procedure. Collectively, though, those courts and the Court of Appeal, they said, we're going to call these, collectively, the Supreme Court. So where's the House of Lords fit in? Well, they said, actually, we only want one final Court of Appeal, and that's the Court of Appeal. But their lordship said, oh, but we'd still like to be involved. They said, oh, go on then. You can still have final say. However, you're not being in our Supreme Court, gang. So the House of Lords was never part of the Supreme Court. Technically, the House of Lords wasn't a court. It was the Judicial Committee of the House of Lords. And when you do cases there, of which I've done one, you just went down like this drab corridor to this committee room with the world's worst carpet, and that will become relevant momentarily. And you'd argue the case there. And it's a weird setting because you would be sort of, robed up with your wigs and gowns and everything, but their lordships, and it was lordships back then, they would be just sat in a table in just regular lounge suits. And it's a lot different to a regular court where you sort of, do your skeleton argument and go through your points. It was a lot more Socratic. It was all back and forth. They'd sort of, ask you questions, and it's like, what about this point? What about that point? So you have to be really good at saying, oh, that's in bundle 27 at page 938, tab X. I was literally only on this case because I was second junior, because I had some technical points from other jurisdictions that they wanted to cover, and I'm quite nerdy. So they said, oh, you disappear in the library and pull all the foreign law books out, and you do your bit and hope they don't ask us. So that was my sole involvement in that. But when they give their decision, you actually trot off to the big House of Lords, the chamber, to do it. Now the thing is, the chamber of the House of Lords, the acoustics there are absolutely terrible. I mean, I used to work for bands and things, so I'm quite good on acoustics, and trust me, that was a bad gig. They're often accused of being asleep in the chamber. They're not. They've got little speakers in the benches, and that's what they're doing. When they're leaning back with their heads like that, they're trying to listen to the speakers because it's all mic'd up, and that's the only way you can hear anything. But just when you're just in there, you can't hear it. It's just mumbling, it's just noise. Luckily, they give you a sheet of paper saying, you know, here's what to do, here's who's going to say what, here's where you walk up. Because you go into the entrance and you walk up on like a little raised area, and they sort of say, walk forward, listen, you know, when you hear the third set of mumbling, just bow and walk backwards and try and count your steps so you don't just disappear into the ether. Luckily, I managed to do that. They also give you the judgment, the full judgment in advance in the robing room. That's not uncommon. It's very common for courts to send out judgments in advance, draft judgments. The idea is you just comment on any typos in there. It's not a chance to argue and re-argue the case. I mean, people try that, but they get knocked back very quickly. You can sometimes say things like, could you just amplify this or address this or clarify this? But generally speaking, it's just to sort of say, this is what we, you know, can you spot anything obvious in it? Have we got the names of the parties correct? But on that particular case, they just gave us them while we were actually there. Now, I sort of scanned through very quickly this, because I had the solicitor on the phone. You know, a chap's in prison wondering how long he's going to be staying in there. The actual opening to one of the judgments was beautiful, because it said the defendant and the deceased had spent an evening in drinking and recrimination, which I thought was really poetic. But I shot to the end and it just said, this appeal is dismissed. It's like, oh no. So, you know, ring the solicitor and go, you know, blah, blah, you know. Luckily, at that stage, our very nice prosecutor goes, Alan, remember, this was our appeal. That means you've won. So, oh, yeah, because I'm just so used to being the appellant, it never occurred to me to, you know, actually be ahead of the game for once. So that's how it used to work. However, they said, like, look, you know, we need to put the House of Lords on a more formal footing. So we'll make it into a real court. And the first thing they did is they gave them a nice, shiny new building to get rid of their terrible committee room. And they took over the old Middlesex Guildhall Crown Court, which was my favourite Crown Court in London, because it's this beautiful building. It's only from 1911, but it looks a lot older. And it is actually already dropping to pieces. There's, like, you know, big cracks in the wall, and there's all these things for measuring how big, you know, how big the cracks are, and lasers pointing everywhere to warn us if it's about to collapse on us. But they took that over and got it all decorated, and they got a new carpet with a new logo. There were quite a few artists contributed to the different logos, but one of them was Peter Blake, and he's the guy who designed the Sgt. Pepper's Beatles album cover. And he designed one of the logos and the one that's on the carpet. And I've actually emailed the Supreme Court and said, if you're ever getting rid of that carpet, I'll take it off your hands, because that's the only way I'm ever going to be able to afford a Peter Blake. But yeah, they got their new sort of, you know, robes and everything, and they sit now as a proper court. However, because they're, you know, the old House of Lords, they're still not part of the Supreme Court. So you have this rather strange situation that the Supreme Court was not part of the Supreme Court, because of the two different meanings. We all thought that was a bit silly. So they introduced something called the Superior Courts Act that basically retrospectively said, right, any reference to the old Supreme Court, that's now the Superior Courts. And just imagine it's always been that. And the House of Lords can keep their new name. So anyway, hopefully you might have found that marginally interesting. If you did, please consider clicking the like button and also maybe subscribing. If not for me, for Lord Loverduck. I mean, you know, just look at him. Can you say no to that?